Judgment in the appeal, Zebotowski and the National Crime Agency.
In November 2006, the statutory predecessor of the National Crime Agency, which I shall call the NCA, began proceedings against Mr. and Mrs. Shepetowski, seeking to confiscate 20 properties, contending that they constituted recoverable property within the Proceeds of Crime Act 2002, on the grounds that they had been acquired with money allegedly obtained through criminal acts. Those properties included buildings owned by Mrs. Shepetowski, known as Ashford House, which was the Shepetowskis' home, Thames Street, Church Street and Claygate, which had all been charged to RBS for a debt of over £3 million, the RBS debt. In 2008, the Shepetowskis and the NCA settled the proceedings on terms contained in a settlement deed. Pursuant to those terms, first, Thames Street and Church Street were sold and the proceeds were paid over in part satisfaction of the RBS debt. And secondly, in early 2009, Mrs. Shepetowski granted a charge over Claygate, which I'll call the 2009 charge, to NCA, entitling NCA to recover a sum of up to £1.24 million from the proceeds of sale of Claygate. The 2009 charge was a second charge over Claygate, as it was subject to the RBS debt, and it included a statement that Mrs. Shepetowski had no liability to pay any money to NCA. In late 2009, Mrs. Shepetowski sold Claygate, and once the proceeds of sale had been used to pay off the outstanding RBS debt, less than £1,400, hardly anything, was left to satisfy NCA's debts under the 2009 charge. NCA then sought to invoke the right to marshal against Ashford House. Now, the right to marshal classically applies when there are two creditors with a common debtor, one of whom has security in the form of a first charge over two properties, the first mortgagee, while the other has security in the form of a second charge on only one of those properties, the second mortgagee. If the first mortgagee chooses to enforce his charge against the property which secures both debts, the common property, the second mortgagee is able to enforce his charge against the property which only secured the first mortgagee's debt, the other property. NCA argued that as the proceeds of sale of Claygate, over which RBS had a first charge and NCA had a second charge, were used to pay RBS, it, NCA, was entitled to look to Ashford House, which was only subject to the charge in favour of RBS, to obtain payment of the sum which it would have obtained on the sale of Claygate if RBS had sold Ashford House and used the proceeds of sale to clear the RBS debt. Mrs. Shepetowski argued that NCA should not be allowed to marshal because first, the 2009 charge did not secure any debt from her to NCA, and or secondly, because the provisions of the settlement deed in the 2009 charge, coupled with the circumstances in which they were executed, demonstrated that marshalling was precluded. Mr. Justice Henderson held that NCA's marshalling claim was well-founded, and the Court of Appeal agreed with him. The Supreme Court unanimously allows Mrs. Shepetowski's appeal in a judgment given by myself, with which Lord Sumption and Lord Reid agree. The 2009 charge did not create or acknowledge any debt from Mrs. Shepetowski to NCA, save that she was bound to pay NCA an amount of up to £1.24 million out of such sum, if any, as remained from the proceeds of sale of Claygate after any prior claim had been met. Marshalling, we decide, is not available to a second mortgagee where the common property does not secure a debt due from the mortgagor, but is merely available as security for whatever amount the second mortgagee can extract from the property. In such a case, there is nothing from which the right to marshal against the other property can arise, and in the absence of express words which permit or envisage marshalling, it's hard to conceive how marshalling would be available. If, contrary to this conclusion, marshalling were in principle available to a second mortgagee, even though there is no underlying debt, Mrs. Shepetowski's appeal would still have been allowed. The statutory background to and the terms of the 2009 charge and the settlement deed coupled with all the surrounding circumstances, demonstrate that the parties did not intend NCA to have the right to marshal. The fact that Ashford House was Mrs. Shepardowski's home is a relevant background fact, but it is quite insufficient on its own to prevent a right to marshal, if such a right otherwise existed. Lord Carnworth and Lord Hughes, the other two members of the court, would allow the appeal, but only on the latter basis, namely that read against the statutory background provided by the 2002 Act, and the fact that the 2009 charge excluded any personal liability on the part of Mrs. Shepardowski, that charge impliedly excluded recourse to any source for payment other than those identified in the documentation, and in particular it excluded the right to marshal.